Have you ever wondered what truly happens to your shared home, your joint bank accounts, or other assets you own with your spouse after one of you passes away? It is a question many couples consider when building their financial future together, and understanding the answer can bring immense peace of mind. When it comes to jointly owned property, wills often do not dictate its distribution. This is because many forms of joint ownership include a right of survivorship, which means the property automatically transfers to the surviving owner upon the death of the other, bypassing the will entirely. This legal mechanism ensures a smooth transition of ownership for shared assets. The core reason for this lies in the way jointly owned property is legally titled. For instance, property held as joint tenancy with right of survivorship, or JTWROS, dictates that the surviving joint owner automatically inherits the deceased owner's share. This transfer happens by operation of law, independently of any instructions in a will. Similarly, in some states, married couples may hold property as tenancy by the entirety, which also includes this right of survivorship, providing additional protection against individual debts. However, not all jointly owned property bypasses a will. If property is held as tenancy in common, each owner holds a distinct, transferable share. In this case, your will can indeed specify who inherits your individual share of the jointly owned asset. To understand how your specific assets will be handled, you should review the deeds for real estate, statements for bank accounts, and agreements for investment portfolios to see how they are titled. It is also important to remember that certain other assets, like life insurance policies and retirement accounts, often have designated beneficiaries. These beneficiary designations also override a will, meaning the funds go directly to the named individual, regardless of what your will might state. This is a common and powerful tool for estate planning that complements, but does not replace, the role of a will. Grasping these different forms of ownership and their implications for your will ensures that your shared assets are distributed exactly as you intend. Taking the time to clearly understand how each of your jointly held properties is titled, and openly discussing these matters with your partner, will strengthen your financial partnership and help secure your legacy for the future.